Good afternoon and welcome to this afternoon session of the Kansas Court of Appeals, meeting remotely with our attorneys today by Zoom. We appreciate your flexibility to accommodate us in this format. We just have two cases set on our oral argument today because the third has been dismissed. And so we will go ahead. I am Judge Catherine Gardner, and I will serve as the presiding judge today. Largely, that means I'll be keeping time. Roughly, it's 15 minutes per side for argument today. And so I'm happy to be seated also with Judge Stephen Hill, the longest serving judge on our court, and Judge Leslie Isherwood. So the three of us will be the panel today. So I will go ahead and call our first case, which is number 123483 and 123696, Tiffany Violet Farha, Appley versus Brock Christopher Oakes, appellant. May I have your appearances, please?
This is Andrew Folston and McDonald Tinker for appellant Brock Oakes.
Good afternoon, Jeff Carmichael and Lynn Ward appearing on behalf of the appellee, Tiffany Farha.
Thank you. And who will be doing the argument?
I will.
On her behalf. Mr. Carmichael, thank you. Ms. Ward, welcome. So with that, we will begin. The appellant, please go ahead and let me know if you'd like to reserve any time for rebuttal.
I have 3 minutes, Your Honor.
You may. Please proceed.
Okay, thank you, Your Honor. This is a pretty factually dense case, and obviously there's a time limit on these arguments. So I'm just going to touch upon what I believe are the most important parts of this case. Just briefly speaking, it's an appeal from the District Court's Division of Properties during the course of the parties' divorce. Following a 3-day trial, District Court awarded assets to my client, Mr. Oakes, that had a significantly less value, actual value, than the assets awarded to Ms. Farha. In addition, the District Court ordered Oakes to pay an additional equalization payment to Farha. Following the conclusion of trial, evidence was discovered that established the actual value of one of the assets awarded to Oakes and valued by the District Court at $2.4 million was actually probably had a value closer to zero. Oakes moved to reconsider the property division based upon the newly discovered evidence. After an appeal was docketed from the original decision, the District Court denied the motion to reconsider. Oakes is appealing 3 matters in this case. First, the original division and method and manner of the division of assets and valuation of those assets. Second, the District Court's denial of the reconsideration due to its lack of jurisdiction because an appeal had been docketed. And third, because of the denial of the motion to reconsider based off the substance of the motion itself. I'm going to focus mostly on number 1 because it does go to a little bit to the last one, and the second issue is mostly just a procedural matter that speaks mostly for itself. But of course, I'm happy to answer any questions as they arise. This case involved the division of illiquid assets that constituted minority stakes in private businesses, most of which were closely held corporations. It is almost impossible to value those correctly. And to do so, you need a lot of information and to go through a careful analysis. However,
let me ask you a question there. Were most of those private, small, or closely held corporations ones involving the ex-wife's family?
Yes, Your Honor, most of them were. That's correct. But so the KSA 23282A provides 3 methods a district court may use when to divide the property. One of those is to divide the assets individually and essentially give a credit to the other spouse. One of the ways is to equally divide those properties. We don't dispute that in most cases, that's okay. What the court did here was go the route of the individual valuation and division of the assets. And again, in most cases, as a general rule, that's fine. That's not our argument. Our argument is that the overriding principle is that a district court is required to make a fair and reasonable division of the party's property. So if one of those methods, even though they're not normally valid, will in a particular case likely or certainly result in a division that is not fair and not reasonable, that method is not acceptable to use in that particular case. And here, the reason that method the district court chose was not an appropriate method was because the parties knew and the district court knew that these were illiquid, largely unmarketable minority interest in private companies. For the court to provide for a fair and equitable division of the property, it had to value the assets reasonably accurately.
Counsel, may I interrupt you for just a second?
Yes, Your Honor.
As I understand your argument, that the court needed to assess the value of these assets, but your client, as I read through this record, did the same thing as the owner of any corporation does, makes an estimate of their values and did so in several exhibits. And there was a request for admissions, which your client never responded to, which the court ultimately ordered to be deemed admitted, and use that information to value these companies. Why should we bother to hear your complaints now when your client never bothered to respond to the request for admissions, saying, no, I may have said that at one time, but I was wrong? I mean, you had the opportunity to do that, did you not?
Well, Your Honor, and I apologize because our firm was not involved in the case at that time, but yes, certainly he could have responded to those requests for admissions at the time. However, during trial, the court allowed testimony regarding the forms, regarding the valuations of the property. And given that allowance of testimony, and given the testimony received, and given the defects in the forms themselves and the nature of the forms themselves, we believe that that evidence should not have been just blindly accepted by the court as establishing the value of these inherently complex and difficult to value assets, especially when the court had the very viable option of just simply evenly distributing the assets between the parties. So there's no risk.
Let me ask you about that. The court evidently made a suggestion that under the circumstances here, and I think that the parties may agree, that Mr. Oakes does not get along with several members of the Farha family. There's all sorts of grievances, perhaps, that we don't need to get into here. Is that correct? The court made that reference?
Yes, Your Honor.
Mistaken?
You're absolutely correct.
And the court took that into account, saying, well, the future does not bode well. If they can't cooperate now, how are they going to cooperate after the divorce? And is that something a court should take into account in dividing marital assets?
The court can take that into account. That's not our argument. However, our argument is that the court cannot overly rely or solely rely on one of the many statutory factors. It has to examine them all. Mm-hmm. So if it just looks at one factor to the exclusion of all the others and makes its decision based off that one factor, we believe that is an abuse of discretion. And the court is also required not only to not just rely on one factor, but actually consider all the factors. And one of those factors the court did not consider was the time, source, and manner of acquisition, especially the manner and source is really the key point that the court did not consider. The court did not consider how much time, effort, money, blood, sweat, and tears Mr. Oakes put into these companies and founding them and getting them off the ground and building them. The court gave no consideration to anything about the manner or source of the acquisition of these properties.
Are you saying the court ignored evidence of that, or was there any evidence presented of that blood, sweat, and equity?
Mr. Oakes certainly testified regarding his extensive efforts in founding these companies and getting them off the ground throughout his personal testimony about how they were formed, how he came involved, how he essentially, had significant efforts in getting these off the ground.
So the court gave no weight to that testimony?
As far as the order it issued, it gave no weight to that. The only thing it considered under this factor was the fact that all the assets were obtained during the 23-year marriage, which goes to the time.
Are you asking us to reweigh then the evidence?
No, Your Honor. I'm asking you to remand so that the district court may evaluate it properly and consider all the evidence instead of just ignoring one of the factors. And that's one of the basis for our request for reversal and remand, is so that the factors can be considered and not just this one factor be overriding everything else. But the ultimate problem is that these assets were almost impossible to evaluate properly. It was almost certain, and in fact did result in a massive inequity due to the misvaluation of these assets. The only evidence received that the court considered was these three forms. These three forms were pro forma bank statements that there was testimony that there was not a concerted effort to make a fair market valuation on these forms. One of the forms themselves says it's not a market value evaluation. Mr. Oakes testified at length about that these forms were not reliable, were not the result of extensive financial analysis, but were simply a form that he sent into the bank as a matter of routine. In fact, the forms themselves provide inconsistent values for these companies. And the district court essentially just arbitrarily chose between those inconsistent values because there was no reasonable basis between choosing one value over the other. And if we look at clear data, probably the most important one, the court just chose 2.4 million based off a single one of these forms that Mr. Oakes specifically testified was a result of a data error entry. The court took that testimony and just, regardless of the clear defects in the forms themselves, accepted that value, 2.4 million, assigned it all to Mr. Oakes, and then gave Ms. Farha a 2.4 million credit. That was 64% of the value of assets that Mr. Oakes received. If the court had split it evenly and we kept all the other valuations, Mr. Oakes would have received $1 million less in assets. And the fact that the clear data had no value at all was pretty clear by the fact that neither party wanted it assigned to them. There's pretty much no better show of the lack of value of something that neither party wants it.
Mr. Folston, let me ask you about that. I think, if I recall, it seems like the minimal value of clear data was not admitted until the motion for new trial. Is that correct?
Your Honor, the specific minimal data was not entered until the motion to reconsider. You're correct. However, sorry, I didn't mean to interrupt, Your Honor.
My question is there any evidence in the record that he could not have gotten that evidence in front of the court earlier?
Your Honor, he tried to get it, and he got it in after trial. I mean, that's what happened. He just did not have that evidence available to him. But there was evidence during the trial that it was minimal. He said the last I've heard is that, it's minimal. And during the trial itself, the fact that neither party wanted it is pretty strong evidence that it has minimal value. That neither party really had any idea what it was worth is evidence that it has minimal value. And in this particular asset, there's no family problems. There's no problem with splitting it down the middle, assigning it equally to both sides, because the court had no way of knowing, no one had any way of knowing what it was worth at the time. And there was no problem with the family dispute for that specific asset, especially.
Now, counsel, this case pended for almost a year, didn't it? Or did pend for more than a year? Or am I incorrect in my understanding of the record?
No, Your Honor, you're correct. It pended for over a year. And I do apologize. Our firm did not get involved until about 3 months before trial. I will do the best to answer off the records that I have, but I apologize if I can't answer it before that. And it's completely understandable, your point, that there was time to establish a value. Mr. Oakes tried, he didn't get the value. But even with the value, even with the evidence we had at the court time, we should have known it was unreasonable to assign this a $2.4 million value and assign it all to Mr. Oakes. That was simply unreasonable based off the actual proceedings before the court at the time.
Mr. Folston,
Yes.
you're getting into your rebuttal time, which you're free to do.
I apologize. I will just very briefly say that this has resulted in a massive inequality and unfair division of the assets. And if had the assets even just clear data had been simply divided down the middle, this would have resulted in a much more fair, much more reasonable division of the assets. And the failure of the court to do so based off the information it had, we believe constitutes reversible error. Thank you, Your Honor.
Thank you. Mr. Carmichael, you may proceed.
Thank you very much. May it please the court, Jeff Carmichael and Lynn Ward appearing on behalf of Tiffany Farha, the appellee in this case. We believe that the briefs that we submitted are well done and we adopt those arguments. The issue here is the court has granted broad discretion in terms of the decision in a divorce on the division of assets between the parties. And the issues here with regard to the issues that have been raised, there's about three themes that I want to talk about and address, which I think go to the heart of the arguments being raised by the appellants. And the first is that there was an abuse of discretion by not applying KSA 232802C, which deals with the time, source, and manner of acquisition of assets, along with other issues. If you take a look at the decision of the district court, the judge took it under advisement, Judge Centano took it under advisement and issued a written ruling. You go to her written ruling, which appears at record volume 1, page 357. On page 5 of that opinion, she specifically states that she took into account the very factors that Mr. Folston said that she did not. If you read the opinion beginning at page 5, the court says that court noted that it has broad discretion in making these decisions, and then noted that it considered all of the factors in KSA 232802C, and in addition, listed 7 additional factors that the court considered in making that decision. Mr. Folston come in here and say now, well, the court only considered the issue of family disharmony. That simply is not true. The opinion clearly states that the judge, took into account all of the important and relevant factors in making this decision. Unless Mr. Folston is channeling the inner judge, trying to figure out what she was doing subconsciously, there is absolutely no basis to make this argument. The opinion clearly states that she took into account the appropriate factors. Issue number 2 deals with the financial statements. Mr. Folston argues, well, the financial statements are just bank forms. No, they're not. They're personal financial statements that were filled out by Brock Oakes, in which he signs at the bottom, and they say, if you look at record volume 11, exhibit 13, he certifies that the information is true and correct in the financial statements that is signed. In order to provide an evidentiary basis for this case to go forward, we filed requests for admissions on every financial statement that we obtained from Mr. Oakes. And we asked 4 basic questions with regard to those financial statements. We asked in the request for admissions on every statement, agree that it's a true and correct copy of the financial statement. Secondly, agree that the financial statement accurately reflects the financial condition of Brock Oakes and Tiffany Farha. Third, that Brock Oakes signed the personal financial statement and the information contained in there in the personal financial statement is true and correct.
Mr. Carmichael?
Yes.
I thought you were done with your list. I'll ask you this and then you can finish. Is there anything on that form where it states that he's representing this as fair market value of these entities, or what is he trying to capture?
I think what he's trying to capture is the value. That's what it says it is on the financial statements. If you take a
It
look
just
at the
says
columns,
value.
he's taking a look at the value that
Okay.
exists there. He gives usually two numbers: the investment that he made, the value of the asset the investment made, and then the resulting value for his portion of it. And we did, in request for admissions, ask, does it reflect, are those financial statements true and correct in terms of the values provided? And he had, not responding, we did the appropriate thing, asking of those requests for admissions be deemed admitted. The judge entered an order, and those appear, I believe, in record volume, I think it's 11, on exhibits 29 and 30. 29 being the request for admissions and 30 being the order of the court.
Counsel, let
Admitted.
me interrupt you for a second if I could.
Sure.
If I understand the procedure that was followed during that, that wasn't a quick process. It wasn't just you filing a motion deeming these admitted. It took a while for that to come to court because you sent notices, did you not?
We did, Your Honor.
To the other side, what we used to call a golden rule letter was sent out. All of that was done. Further time was given and still no response.
That's absolutely true, Your Honor. We gave every opportunity to Mr. Oakes and his counsel, and Mr. Oakes, when he was pro se, to respond appropriately to the request for admissions. The court ordered and granted time, and they simply failed. The other side simply failed to respond. At that point, then the court entered an order deeming them admitted. And once they're admitted, those become evidentiary in value. It's an admission by Mr. Oakes with regard to the numbers that are contained in those financial statements. And what the judge did, by the way, as we point out in our briefing, if there were two numbers provided, Judge Centano used the lower number when those items were assigned to Brock Oakes to be fair to him, so they weren't using the higher number that would be to his disadvantage. And so Judge Centano took into account the request for admissions, the valuations that are contained there, and concluded that this is the way the division should be handled.
Counsel, I know you don't have much time. I want to ask you a question of what gives the court the authority to look into this familial disharmony, as you phrased it. What gives the court the authority to look into that when deciding the division of marital assets?
I think in terms of it being fair, just, and equitable, if there's an issue that would result in continued disharmony, continued litigation, which, by the way, was the threat that was made, that Brock Oakes was going to sue Tiffany's family, that he was going to engage in violence with regard to Tiffany's family. I think what the court did is appropriate under that fair, just, and equitable division standard, that this was a way in which further conflict could be avoided and still provide an equitable division for both of the parties, both Brock and Tiffany, to receive from the divorce. I think it's entirely appropriate. The judge, in the decision that she rendered, identified the factors that she took into account, one of which was family disharmony.
Now,
and it's not the sole issue.
The last question I have for you is, can we revalue assets? Can we reweigh the evidence? Do we have such authority to reweigh the evidence?
I do not believe so. I believe the issue on appeal is there any evidence to support the decision of the district court? And I believe that there is a wealth of evidence upon which Judge Centano based her decision.
What is the evidence that supports the fact that one, I can't think of the name of it now, is worth 2.7 million, which Mr. Oakes contends is worth zero now?
It is actually contained in the financial statement. I believe it's financial statement exhibit 14 or 15, and it has a listing In an explanation, by the way, it says that the company raised $240 million and that Mr. Brock Oaks owned 1%. And so in his financial statements, he does the math, and it's $2.4 million is the value of the company that Brock Oaks owns 1% of. He owned $2.4 million worth of value in that company. That was admitted. It was a request for admission, and that's placed of evidence. And by the way, it's important to point out that in that financial statement, he also says, if you have any questions, here's the CEO, president of the company's name. You can contact him and verify it. That's the person that they got the affidavit from in the post-trial motion to establish that there was some other value for the company other than $2.4 million. And a couple of things on that. One is I don't find the affidavits anywhere in the record. I looked, I didn't find them anywhere. But secondly, there was a question raised by Mr. Fulston that Brock Oaks testified at trial. There was a reduced value. He tried to. I objected based on hearsay. That was sustained. That evidence didn't come in. But in addition, at the post-trial motion, Judge Centano asked repeatedly, why wasn't this information available at trial? And there was no good explanation provided. But in addition to that, if you take a look at the question that was raised, it is clear data, and there is no evidence admitted, no evidence provided, other than Mr. Fulston's argument that there is a reduced value. At the time at which Mr. Fulston's firm entered into this case, they filed a motion to extend the trial date and to add expert witnesses. You can take a look at, I believe it's the last portion of the record on appeal. That's the order granting them the right. And then they went ahead and designated experts. Why didn't they designate an expert on the valuation of clear data? Because they knew exactly what we were going to do at trial with regard to its valuation. The people that they identified in their initial designation of experts, they either didn't provide an expert report and they were stricken, or secondly, they did provide an expert report and they simply weren't called at trial. Those are decisions made by the appellant in this case at trial. They had an opportunity, they failed to act. That does not provide a basis then post-trial to get a new trial. I think the old adage is you don't get a perfect trial, but you get a fair trial. These are decisions that they made.
Counsel, if I may say something about the record on this case, ordinarily in these high asset divorce cases, the parties hardly ever testify, but there's expert witness after expert witness after expert witness that does testify with reams of material. And I don't see that in this particular record.
That's true, Your Honor. At the point at which the requests for admissions were deemed admitted, we had an evidentiary basis then for the valuations, and it came from Brock Oaks. Why would we want to hire experts and spend that money when we have those numbers admitted? And they were then taken into evidence by the court, and the court relied on those numbers because they were requests for admissions deemed admitted with regard to valuation of the various assets, then used for division by the court. It would have been a waste of time and money for us to bring people in to say, yeah, those numbers are right. We had admissions.
And Mr. Carmichael, do I remember correctly from the record that those numbers available on the financial statements, those were professional appraisals. Those weren't hypothetical numbers arrived at simply by Brock Oaks. Is that correct?
I believe that there wasn't a reference to there were appraisals on many of those numbers that were provided. But I would also point out that Mr. Oaks got his advanced degree from Columbia in real estate development. and holds himself out to be an expert. I think that there was a sufficient basis for the valuations that were provided and admitted and then relied upon by the court. That process, Lynn and I went through it and thought about it and thought this is a legitimate and reasonable use of requests for admissions. Once they're deemed admitted, we can rely upon those as valuations, as reasonable valuations in this case. In terms of the post-trial motion, again, I don't see the affidavits as part of the record on appeal, and I don't know how you can rely on that then as being an alternative valuation if there's no evidence in the record that supports that. Mr. Fulston saying it's true is nice, but it's not evidentiary. It's not an evidentiary value. And I think the court did the appropriate thing when she ruled there's no evidence as to why you couldn't have produced this evidence at trial. And secondly, I gave you an opportunity when I continued the trial to submit expert reports and you failed to do it. No basis for a post-trial motion for the
Do we
reasons
even have
posed.
jurisdiction to consider that issue?
I believe you do, Your Honor. The argument that was raised in the briefing was the notice of appeal was filed the next day. The decision was issued. And that's not the issue. The issue is when was the case docketed? At the point at which it was docketed, there was a post-trial motion pending and not yet resolved. And so I believe once the court made that decision, it was then ripe for appeal and the case proceeded. But I believe based on that scenario that there was an appropriate basis for jurisdiction for this court to have considered what was done post-trial and rule that it was appropriate.
Mr. Carmichael, you have about 1 minute remaining.
I'll grant it back unless anybody has any questions. I'm done.
Very good. Thank you. Mr. Fulston, you have 3 minutes.
Just want to quickly address just a couple matters. And I want to focus mainly on clear data because of the limited time. There were 3 bank statements provided that the sole basis for the valuation of these complicated companies. 2 of those forms said TBD on the value. One said 2.4 million. During trial, Mr. Oakes testified that was an error in the data entry that had no basis. And the court just arbitrarily chose one of the 3 forms as assigning establishing the entire value of this asset. An asset that,
in conjunction with his testimony, Mr. Fulston, did he offer any substantiation of that reduced value?
of the reduced value, Your Honor?
Aside from just simply his testimony?
Well, 2 of the statements said TBD, as in there is no value that I can assign to this. And the court just arbitrarily chose the 2.4 million. Whereas
one that he agreed to.
He said it was erroneous. I mean, in his testimony, he said it was an error. But what we asked to do was just say, you get half of it, we get half of it. So no matter what the value is, it's not going to be inequitable. And there's no family concern with that business. There's no any kind of concern about the family obligations with that, with that specific asset. There's no reason that specific asset should not have been divided evenly, given the lack of proper basis for the valuation of that asset. And instead, because that was awarded to Mr. Oakes solely, that was 64% of the value of the assets. If it had been assigned evenly, that would have meant he got $1 million less in assets than Ms. Farha. And again, our argument is that was unreasonable based off the lack of basis for evaluation of that asset, the lack of any familial problems with that asset, and the ultimate inequity that it resulted in the course the district court took.
So, Mr. Fulston, it sounds like you're asking us to do equity. I mean, he had admitted that the Clear Data bank statement of 2.4 million was true and correct as a value for that company. But you're saying then the judge should have come back because he said that was in error and just halved it. You're asking us essentially to do equity, or that you're faulting her for not doing so.
I'm saying that given those circumstances and the two other financial sheets which said TBD, one before that 2.4 million and one after, that to assign $2.4 million in assets to Mr. Oakes and to give Ms. Farha 2.4 million credit based off one of three financial statements and the evidence undertaken, that was an abuse of discretion. That was unreasonable, and that resulted in a massively inequitable ruling.
Thank you. Any other questions, panel? Thank you both for your good arguments. We appreciate the briefs as well, and we'll take the case under advisement.